has any issues hearing any of us, please let us know. You can probably respond through the Q&As on the side, and one of us will see that and track down and help resolve the issue. We appreciate everyone joining us today. We have a very diverse group of participants from all across the country, many different types of employers, and it's interesting to see that even though COVID has been going on now for approximately, I guess depends who you ask, 8 to 12 months, there's still it's still an ever-growing and ever-changing topic. And what we thought last week may be different, things just continue to change, and so that's what we're hoping to discuss here, is give you some ideas of what's going on, how you can protect yourself, how you can protect your employees, and what other impacts we are seeing as a result of COVID-19. Today you'll hear from myself, Tyson Horrocks. We also have Deborah Lake, Jeremy Merkelson, and Roger Sy. All are very well versed in these issues and have been dealing with them since the outbreak. Again, this presentation is just meant to provide general information on pertinent legal topics, educational purposes only. It's not meant to constitute any legal or financial advice, nor does it reflect the views of Hall & Hart or any of its attorneys, other than the author. If you have any questions about anything you see in this slide of this presentation, please reach out to one of us. We will likely have to cover things fairly quickly just because there's so much information out there. We'll do our best to cover it. We want to save some time for the end for questions and answers, and so if we can, we'll try to address all of those. If not, feel free to reach out to one of us. And so there's kind of the agenda for today, but in the essence of time, I'll skip over that. And we're going to start with returning to the office safely. This is something that we've obviously been dealing with since probably about May, when companies and businesses started to reopen. And what's important to realize is not all states are the same. And so we recommend talking with your legal counsel, talking with somebody, coming up with plans and understanding what applies to you. As a starting point, there are a few various organizations that kind of navigate these guidelines. First and foremost is OSHA, which requires that all employers provide their employees with a workplace free from recognized hazards likely to cause death or serious physical harm. Next, we have the CDC, who has created a lot of interim guidance for employers to slow the spread of COVID-19 within the workplace. And then we have the lovely EEOC, who handles laws such as the Americans with Disability Act, Rehabilitation Act, and other laws regarding the COVID-19 pandemic. It's been very interesting to watch the EEOC guidance as it's come out. It's tended to be probably a little more employer-friendly than we're used to seeing out of the EEOC. Now, it remains, open to see how that's going to change or remain the same, considering we now have a likely new administration coming in, kind of change from the Republicans to the Democrats. So that's something that we'll want to keep an eye on as to how the EEOC guidance possibly is impacted. So first and foremost is creating a safe workplace for your employers. It's important to encourage employees to check themselves for symptoms and stay home when not feeling well. You don't want to be the company that makes the news because you forced your employees to come in when they weren't feeling well. You're generally speaking, you're best to err on the side of caution if your employees say they are showing certain COVID symptoms. But if you have questions, feel free to reach out to us. Also, we advise creating an action plan. What do you do if the employee becomes sick or tests positive? What happens if they show symptoms during work? You want to immediately separate the employee from other employees and send them home. Close off areas used by all employees and disinfect them according to CDC standards. We recommend referring to those CDC guidance on how to clean and disinfect areas of potential exposure. The CDC has a lot of information out there about what you should use, how they recommend it, and we'll cover a little bit of that here in this presentation. Follow the CDC and local guidance for when an employee can return to work. You can, when it's COVID-related, ask for a return to work for fitness for medical notations. Determine if you need to inform OSHA or any other public health agencies. Again, investigate. And then we actually have an entire COVID-19 resource site. If that hasn't been provided to you, I'm sure we can find a way to provide it. It has a lot of great answers. We have updated it as the COVID has changed. Early on, it was how to handle these COVID outbreaks and what COVID means for the workplace. Now it's much more structured on how to open up the workplace and do so safely. Again, there's kind of three different ways of how you should handle and approach these safety. First is document, put plans in place, make sure your employees are aware of these plans. Talk about how visitors should be screened, if visitors are even being allowed. Then it's important to train your employees on these policies, and again, communicate with the employees as new policies come out, new safety regulations. Self-monitoring is probably the best way for people to catch and know what's going on. We can do questionnaires for workers coming into a workplace. Have you been exposed to anyone with COVID? Are you showing any COVID-like symptoms? But again, when we start asking these type of things, we need to make sure we're not going beyond COVID questioning. And in a rare change of regulation, the EEOC has come out and OSHA are allowing temperature checks of employees. Usually that goes a little bit beyond what is permitted, but we do have that exception for now. Again, we want to keep track of what's going on. So how do we develop a plan? One thing is we can identify a COVID-19 coordinator for the company. Obviously, not every company is going to have that ability to do so, but we do recommend having someone in the company that can kind of be the point person. Update your leave policies as necessary to make sure that you're covering for the newly implemented leaves, or at least make sure you have a good understanding of them. Consider how to screen employees. Create an update for emergency communication and responses. How do you communicate with your employees if there's an outbreak, if you need to shut down? Make sure you're doing those. Work from remote where possible. Obviously, this isn't possible for all positions, for all companies, but the CDC is recommending that where remote working is possible, that you continue to do so. Consider PPP and other precautions. What can you do in your workplace to make it safer? Minimize face-to-face interactions. Everyone is slowly becoming experts on Zoom, WebEx, whatnot. Eliminate unnecessary travel, meetings, conferences, workshops, and training sessions. Again, with Zoom and WebEx and all these various meeting organizations, electronic, we have a lot more flexibility. Again, this is not a one-sided issue. Employees and employers both have to buy in and do their share. Your mitigation strategies may depend on what your exposure in the community is. Some areas have lower risk, lower exposure. Other areas are higher. And so the more risk you have, the more you need to be taking into account what plans to be in place. One thing you need to do is make sure you assess your workforce. Look at people that you have that might be higher risk. Again, we're not looking at age discrimination or ADA violations. It's just for implementing plans. Do you have people that are higher risk, age 65 and over, nursing homes? This kind of talks about who are your high risk categories. You may need to take that into place as you're implementing a plan on how to properly distance people and protect the employees. Again, know your workplace. Implement cleaning protocols. Consider staggered schedules. We've started to see that happening a lot more as companies are returning to work. Can you social distance employees? Can you provide masks? One thing we're also seeing a little bit of is employers who are encouraging their employees to work from home, but employees are saying they want to come into the office. So how should we approach that? There are some states that have started to implement general workers' comp protections for the company for any COVID exposures, but also it might be worth having the employee sign an acknowledgement saying that they understand the risk that they are exposing themselves to by coming into the office, that they understand the COVID symptoms, how to handle that, and that they are choosing to come into the office as opposed to work from home. Again, implement testing policies, consider having a daily routine, immediately send home any employees that have COVID-19 symptoms, ensure all screening and communications are confidential, limit the number of employees designated as screeners to ensure their safety. Again, we're wanting to limit exposure. Avoid questions that might reveal other non-COVID-19 related health issues. This is an issue we're starting to see more and more as employees are asking for accommodations, asking for help, and we need to make sure we're not going beyond the COVID-19 questions And if we are going to, we need to make sure we're doing so properly under the ADA or maybe FMLA and following those procedures. Then determine how the company will handle employees that refuse to be screened. We recommend that you consult with counsel before disciplining any employees. That way we can help walk through the risks. Create a safety training for returning employees and communicate with employees clearly and often regarding the precautions and procedures. Some of the common procedures we see: wear masks, clean and disinfect things you touch, wash hands often, avoid touching your eyes, cover your mouth, clean and disinfect frequently, avoid using other employees' phones, desks, products, etc., and practice social distancing. All seem fairly easy, but we do see difficulties in implementing and enforcing. As we mentioned earlier, the CDC has a lot of recommendations for cleaning. Again, I'll try and skip over this a little bit because we are short on time. One thing you need to take into account is what type of surfaces, and another thing is how often are these surfaces touched. Are they high traffic areas, low traffic areas, etc. Best practices that we have for social distancing and workplace hygiene: again, retain or offer work from home options whenever possible. Consider alternating shifts and change hours to reduce employee headcounts and crossovers. Limit the number of in-person meetings. Limit non-employee visits. Limit or restrict gatherings in public or common areas. Request employees to routinely clean and sanitize. Restrict movement. Increase ventilation where you can. Limit the number of individuals in elevators. Provide intermittent breaks for hand washing. Provide no-touch disposal receptacles. Discourage use of contact methods of greetings. Stagger breaks and lunches. Keep doors open where possible, and limit the number of customers on premises. Again, all these best practices are going to fluctuate depending on what your business is, how many people you have in there, what's your requirements. Are you a production facility where you're required to have people in there building, creating, marketing, whatever it may need be? Think about what you need and then create a plan. Once you have employees that test positive, it's important to do contact tracing. Try and figure out where do they trace contact within other employees. What sort of exposure do you have in your office? Who needs to be potentially quarantined? There are a number of contact tracing providers out there. One such company is called Blinkseed. They're one of our clients. We work with them, and we've worked with them on creating their policies and what's going forward. But again, make sure you have these plans going forward, and make sure you're implementing them and that your employees are fully aware of what your policies are. However, one thing we are starting to see, and we see this a lot, is employee wellness. Human individuals are generally not made to be, alone and introverted. There's a lot. Some people may like that, but there's a lot of people out there that they need the interaction, they need the connection with people, or else they start feeling lost. Keep track of your employees. Check in on them, make sure they're doing okay. Publish a workplace newsletter. Here's just a few ideas. Create private social media groups, create visual break rooms, stress circles, support groups, virtual exercise challenges, something that encourages interaction while also doing so safely. Now, of course, if we're going to have employee wellness, we've got to make sure we aren't going to step outside the policy, outside the rules and laws. National Labor Relations Act allows complaining. It's we don't want to try and provide a service to our employees and then step in traps. So let them talk, let them vent. Things are frustrating right now. Employees are dealing with difficult issues, just like we as employers are. Etiquette rules should be provided. Follow the golden rule. Treat others like how you'd want to be treated. No inappropriate content. Now, as far as navigating government mandates, and I only have another minute or so I'll go through these fairly quickly, it's important to know that each state has their own different policies. There are the federal rules. There's the Emergency Paid Sick Leave Act, the Emergency FMLA extensions, those sorts of things that apply generally speaking. And I know we've done a number of presentations on those myself. I've probably done 2 or 3. And so if you have questions on those, on how to implement or enforce those, please give us a call. We're experts on those. We deal with those new emergency acts quite often, pretty routine nowadays. But you also need to know, what does your state require? What I know here in Utah, our governor just came out on Sunday night and issued a new mandate. It's important to understand, how does that apply to you? How does that apply to your employees? Again, navigating how to return employees to work. When making these decisions, make sure it's objective. You can't base a return to work on, age or disability claims. You need to, make sure you're doing taking the appropriate considerations. And so, again, all these talked about the ADA, FMLA, some of the extensions that have gone through. Again, if you have any questions, reach out to your counsel. We are trying to do our best to stay up to speed on these. We can more than likely provide the answers you're looking for immediately, or if not, we can at least find someone who knows the answer. So, again, here's a bunch of resources we have. Refer to our coronavirus resource site, and I will now turn the time over to Deborah, and we can turn to questions later on.
Fantastic. Thanks, Tyson. And I think I even have control over the PowerPoint, so things are already going well. So as my slide says, I'm going to be talking about some of the latest in the labor and employment realm and COVID, particularly the cases that we're starting to see pop up. I'll also try to monitor the Q&A on the side here, but it can be challenging to do the presentation and the Q&A. So if I don't get to it in the stream, I'll get to it at the end, or you can always email offline as well. Okay, first big thing I'd like to talk about is what happens when there's a positive COVID test in the workplace. What kinds of claims are we seeing around this? I guess before we get into the lawsuit, Tyson did a really good job of talking about what to do when this happens. In Colorado, there are a bunch of orders in place saying that you need to send the employee home, increase the cleaning, and make sure that you're paying them under the emergency acts. But once you've got somebody who's tested positive, some states require that you notify the other employees that they may have been exposed. These are states like California. But not every state has those types of notification laws in place. But regardless, there may be other obligations to tell employees about the potential risks in the workplace. For example, we've got a lawsuit pending in Illinois. This is against Walmart. It's a wrongful death claim, but it's also a tort claim, where the family of somebody who died after working at Walmart is saying that the company failed to warn the employees about what was going on and also failed to protect them by providing protective equipment. So some of this is just saying that the company wasn't as safe as possible. Some is saying that the company is hiding the ball. We'll have to see how the wrongful death claims and the tort claims play out over the long haul, but we are starting to see more of that. Another tort claim that we're seeing pop up more and more is a nuisance claim. So these are like workers at McDonald's who said that they were forced to work in cramped conditions with dirty masks and dirty gloves, and saying that the company was prioritizing making money over protecting the workers. Similarly, there's a case against Amazon right now where the workers are saying that they were forced to continue working after being exposed, but they weren't told about being exposed, and that because of the conditions in the workplace, they were at risk. Last week, the judge in the Amazon case threw out the case. The judge said this isn't the court's place to determine this type of claim. Instead, this is really an issue for the Occupational Safety and Health Administration, for OSHA. The judge said that the Amazon workers could refile the case if they wished, but at least in the short run, their avenue towards relief is limited. So let's talk about OSHA a little bit, what that judge said courts should defer to. The issue with this is that the Department of Labor is incredibly backlogged. It just does not have the resources to investigate all of the allegations that it's received. Since February 1st through November 5th, which was the time that I looked up this statistic, OSHA's gotten over 40,000 complaints, And to put that in perspective, in Colorado, where I'm based, OSHA's issued only one citation at the JBS Foods in Greeley back in September. So now, of course, workers are upset that OSHA isn't taking their claims, and workers are starting to sue the Department of Labor itself. There's a group of meatpacking workers in Pennsylvania who were one of the first to bring in this type of claim, where they're suing the Department of Labor for acting arbitrarily and capriciously and failing to seek relief on their behalf. So even if the workers aren't suing the employer directly, all of the employer's practices are still going to be involved in these cases against the Department of Labor. And as courts start to defer to OSHA and OSHA starts to not do much, continues to not do too much, we expect to see these types of cases against the Department of Labor popping up more and more frequently. Another thing to note on this is that if you have a positive test in the workplace, there are going to be state and local requirements. These could be requirements to report the exposure in a number of counties in Colorado. Once you've got 2 positive tests in your workplace, it's considered an outbreak, and then your reporting obligations are increased. And then, of course, you also have the obligations to send the employee home and do all of the cleaning and more. In Colorado, we had a new public health order as recently as November 2nd. These state and local requirements are changing all of the time, so it's important to stay on top of it, like Tyson said, as much as possible. Now, ways to avoid having a claim based on a positive test in the workplace would be to have a policy in place where you are trying to communicate as much as possible the exposure that occurred while keeping the identity of the person who tested positive, keeping that identity confidential so that you don't run into privacy risk. But nonetheless, having a policy in place so that if this were to happen in your workplace, you know who you need to inform, who you need to report it to, and you're as transparent as possible so that your workers don't think that that their safety has been jeopardized. Okay, the next thing I want to talk to that's COVID-related is the WARN Act. And this stands for the Worker Adjustment and Retraining Notification Act. And under this law, employers who are about to have a mass layoff and some other conditions, but mass layoff is most key in the COVID world, they have to give their workers 60 days notice of the layoff. We're starting to see cases pop up about this too. There are some enterprise workers who have sued the company. This is a class action suit where they're saying that they were not given the proper 60 days notice before they were laid off. They were laid off back in April. The company is saying, well, hold on, there's an exception in place under the Act where if there are unforeseeable circumstances, we can do the mass layoff without giving the requisite days notice. The workers respond by saying, okay, maybe it was unforeseeable back in January when we had barely any cases, but by the time April rolled around, it was a little more unforeseeable. This is still relevant today, even in November. I'm still drafting WARN Act notices all the time. More mass layoffs are coming. And as the layoffs continue, this exception for unforeseeable circumstances is going to be harder and harder to prevail upon, because at this point, everybody knows that we're about to shut the economy down a little bit more as winter comes, unfortunately. So if you're thinking in your workplace about doing a mass layoff, just try to give the 60 days notice whenever possible. This is the last issue that I want to talk about, right to remote work. So we're seeing cases that pop up under the Americans with Disabilities Act. So, for example, in June, somebody accused his employer of disability discrimination because he wanted to work from home and his employer said, no, you need to come into the workplace. He said that remote work should have been an accommodation under the Act because he was scared of getting COVID in the workplace. In the past, courts have been very skeptical of this kind of argument. Courts have frequently said if the employer thinks that physical attendance is important, the court is not going to second guess that employer's business judgment. and is going to deny right to remote work as a reasonable accommodation. But as we've seen over the last several months, remote work is more and more possible, and especially with the new administration coming in and the new group at the EEOC that we anticipate, the EEOC may become more aggressive in arguing that remote work should be considered a reasonable accommodation under the Act. So for now, we don't know how this is going to go. We know what the past has said, but this is something to be very cognizant of as we're dealing with remote work. The other remote work implication with COVID is under the Fair Labor Standards Act. So if you've got non-exempt employees who are entitled to overtime under the Fair Labor Standards Act, you need to be very careful about tracking their time, making sure that while they're doing remote work, that they're clocking in when they're supposed to be clocking in, and that they're clocking out at the end of the day. It's getting harder and harder to shut off our computers, at least for me, and for non-exempt employees in particular, you need to be careful about not having them be essentially on call, where they should still be monitoring their email after 5 o'clock at night. Because if they're essentially on call, there may be obligations to compensate employees for that additional time. So to minimize any liability risks here, make sure you've got a policy in place that very clearly communicates to workers that they need to clock in and clock out, that off-the-clock work is strictly prohibited, that if employees wish to work additional hours, they need to make sure it's authorized by their supervisor. And if they end up working those additional hours, they'll be paid for that time, but they may also be disciplined so that employees have very clear guidelines about what they should be doing. So those were the three big areas I wanted to talk about: what to do when you've got potential exposure in the workplace, what to do if you're thinking about a mass layoff, and then those implications with the right to remote work. And the key takeaway here is just to make sure you've got policies in place as much as possible so you know how to anticipate what is to come. And with that, I will turn it over to Jeremy.
Thank you, Deborah, and hello, everyone. My name is Jeremy Merkelson. I hope you can hear me okay. My subject for today is protecting company data in the new normal. It's a subject that I think deserves some focus. If you haven't already, thinking about what you're doing about protecting company confidential information now that almost everybody is working from home and almost everybody is using technology that may or may not have the same levels of protection that working in the physical office space has. So the first issue that I want to talk about today is what does it mean in terms of working from home, to have mechanisms in place to protect company confidential information. You'll want to take extra precautions, certainly to make sure if you're a company that prides itself on having trade secrets that have value, particularly in businesses that could easily be replicated by others if they had that information. You want to make sure you take extra precautions to ensure that highly sensitive information is not shared by unsecure or insecure methods. And then non-compete agreements. Not every company needs to have non-compete agreements with every employee, but I urge you to think about whether or not your existing non-compete agreements are really necessary and to make targeted decisions about using non-competes with those that could cause damage to your business if they left to a competitor. And so I just want to quickly talk about that today as well. The most important thing that I want to discuss today with you is having policies. You've probably already seen a lot of guidance out there about updating your policies or at least having temporary policies for COVID times. But if you have not already, I urge you to take another look at your company's standard confidentiality policies, whether it's in your handbooks, whether it's a separate policy, whether it's an email that's gone out to everyone during COVID reminding them of their obligations, to ensure that you have taken the appropriate precautions to address treatment of confidential information while working from home. That means potentially complying with your company's standard internet use and network guidelines. It may mean having stricter security protocols depending on the circumstances. Having somebody who is an expert in IT and in security, particularly IT security, involved in developing those protocols is really important. Again, not every company may need to do this, but companies that really could be harmed severely by breaches of confidentiality should really do this if they have not already done so 8 months into the pandemic. You should address these items in your policies. And then, of course, to remind everybody who's working from home, hey, while you're working from home, the company has the right to monitor use of your use of company resources and the network. Even though you're working from home, you do not have carte blanche to use our devices or our network to engage in violations of company policies, violations of laws, and so forth. So that's all pretty straightforward. Of course, in addition to having those policies, you'll want to, revisit all your other company policies as well, including social distancing, scheduling, travel, benefits, and just general work from home policies, including those that Deborah was talking about in terms of timekeeping, working on the clock, and notifying supervisors when you might be on call to ensure that you're not working at times that are not authorized by the company. We have, I think one of the things we wanted to try to emphasize today with everyone is that we're entering a sort of a new frontier here. This trend has been happening for a long time, but COVID has sort of really pushed us over the edge into this new workplace. The remote workplace is going to be here to stay. And so even though these policies that you're going to develop, if you have not already, are applicable to the COVID environment, they may be useful for the future. So, considering remote work where possible, considering flexible and staggered schedules, reducing the possibilities of employee interaction during COVID, and setting up a process for approving necessary travel, all things you're going to be thinking about. And I think if you take anything away from what I've said today, it's that you may want to remind your employees about what these policies are during COVID. Reminders. Send out a reminder. Remember, these are the policies that we've got. You should be aware that even though we have a handbook, we have these additional policies during COVID. You remember to have safe and secure use of our network and company resources. If you end up in a dispute, particularly a trade secrets lawsuit, it's going to be really important that you take reasonable measures to protect your trade secrets. One of those will include possibly reminding your employees about what these policies are. In the event that they violate them, you've at least created that reminder. And a reminder about trade secrets protection for all of you who may not have followed this. In 2016, there was a law passed by Congress that gives federal jurisdiction and a new statute that protects trade secrets. It's another avenue for companies to sue former employees or for companies to sue other companies with respect to trade secret misappropriation. And I highlight that now because there's talk in the Biden administration that is coming about having a federal statute that deals with non-competition laws. And there has never been a federal statute in this area. It's arguable that that it's not constitutional. We'll see whether it ever gets passed to have such a challenge. But this is an area where we see much greater focus by state legislatures. Non-competes during the pandemic are something that you'll want to really think about before running to the court to enforce. It definitely makes sense as a general matter for businesses to discourage employees from taking valuable trade secret information to competitors. But as with all employment laws, there's a societal impact. And judges may be swayed during the pandemic, particularly that if the non-compete is going to prohibit somebody from gainful employment, that you have a pretty high bar during the pandemic of showing what the real damage will be to your business if the non-compete is violated. If that damage is simply money, you're not likely to be able to get an injunction. But if you're able to show that your trade secret information is really at risk, then you're likely to be much more successful. So for all companies that have non-competition agreements and have a history of trying to enforce them, my guidance really is to be judicious in this era about whether it's really necessary to enforce them, because you're up against, I think, a skeptical judiciary at present dealing with these cases. I've seen it over and over again during the pandemic, and it's only more so the longer this drags on. Going back to just the topic about trade secret protection, this dovetails with what I was saying earlier about having policies in place to protect your confidential information. You know, you may find that what constitute reasonable measures in this day and age of protecting your trade secrets is actually a greater burden than what it would have been before COVID, because you're using home computers possibly, or devices that don't necessarily belong to the company, because you're using networks that may or may not be as secure. It may be easier for third parties to get access to your most sensitive confidential information. And so in this slide, I have a few suggestions, but these are by no means the entire list, and by no means necessarily what a court would construe as being reasonable measures. It really depends on the circumstances, but you should consider using encryption if it's really sensitive information. Not using cloud-based platforms to distribute data like Dropbox or Google Docs, although those may be secure depending on the circumstances. Making sure that the data that you want to transmit is at least password protected. And again, reminding employees over and over again, reminders about their obligations, even while working from home, that they still have to follow the rules. As I was talking about a little earlier, there may be a federal statute in the works for dealing with non-competes. We'll see if that actually ends up on the agenda. Something tells me that there are bigger fish to fry before we see such a statute in Congress. But if it doesn't pass, you should know that there is already a changing landscape with respect to non-competes. State legislatures have been taking action recently, and these are just a few examples, but in Massachusetts, non-competes are now unenforceable against non-exempt workers, so hourly workers and employees who are fired without cause, no longer enforceable under Massachusetts statute. California, for a long time, it's been the case, but it's still the case that non-competes are banned except in case of a few limited exceptions, such as sale of a business. In Colorado, we have a non-compete statute, but we also have a specific provision dealing with physicians and medical practices, such that you can't enjoin a doctor from the practice of medicine. You can only get the damages. In Illinois, there are non-competes that are unenforceable by statute for lower wage workers, just as in Massachusetts. But white-collar professionals may still be restricted. And in Washington state, a laid-off employee must be not compensated during the period of their non-compete. Essentially, you have to pay people for the time that they sit out. So, as a general reminder, as with any non-competes, you'll want to consult with an attorney, certainly before trying to enforce a non-compete. Highly encourage you to consult with an attorney before drafting a non-compete, and being mindful that in this changing landscape, having a narrower focus that's really tethered to protecting your company's most sensitive confidential information is going to be the key to ensuring that it can actually be enforced. That's pretty much the thinking behind that. So a few considerations, just rounding out this discussion of non-competes. Why would you sue for a violation of a non-compete? Well, you can get an injunction, and you can get someone to stop actually doing whatever the competitive activity is. You can get damages in terms of lost profits. You can get damages in terms of unjust enrichment. And then you may be able to get attorney's fees and costs depending on the jurisdiction or what the contract itself says. But these lawsuits can be costly. They can take a long time. And remember that the public interest at this present moment is going to be somewhat hostile to enforcing them during a pandemic, particularly if the worker is not compensated during the restrictive period. And of course, if you do decide to pull the trigger on a non-compete lawsuit, you should be thinking about what Pandora's box that might open. You could open counterclaims for wrongful termination, wage claims, misclassification claims, other claims for discrimination. So you'll want to be prepared. The last thing I just want to talk about very quickly today is the risk of hiring employees with non-competes. We talk about the inbound and outbound risks of hiring new employees and letting employees go. As with any hiring of a new employee, it is wise to check to make sure that employees are not coming to your workplace with a non-competition agreement. It's a standard question that's usually asked on intake forms, but if you're not asking that question, you should be mindful of it and ask. And you'll want to ask new employees to acknowledge in writing that they're not going to violate an existing non-compete by taking employment with your company. When to introduce or modify a non-compete agreement, suggest thinking about this when you've got a new employee. For existing employees, if you're going to condition continued employment on it in some states, you can do so without providing additional salary or bonus. But in some states, that's not enough. In some states, it's sufficient to just allow the employee to continue working, and that's enough consideration for the agreement. In balance, I just remind you again to send your reminders to your employees about the policies. They need to be modified for COVID. The workplace has changed. It will be different in the future moving forward, and we should all be ready for this new frontier. With that, I will turn it over to my partner, Roger Tsai, who is an expert on immigration.
Thank you, Jeremy. Appreciate that kind message, and I'm just going to move forward here. So immigration, there's obviously been a lot that's changed due to COVID. I would have never thought that our borders between Canada and Mexico would have effectively closed off, but I think employers who work with immigrant workers are aware that the landscape has dramatically changed. And I want to get very granular about what has changed so that you kind of have a very full idea and detailed sense of what has changed and what hasn't. Because certainly there are things that have not. So here are some of the things that obviously have changed. And so we work with a lot of high-tech companies and healthcare hospitals to basically keep immigrant workers who've maybe studied at local universities, University of Utah or CU Boulder, here in the United States. Some of these workers have come from abroad, so think Indian software developers and electrical engineers from China. Anyhow, due to COVID, lots of travel restrictions, obviously between the United States and Canada, as well as Mexico. The border is effectively closed to non-discretionary travel. And what that means is any travel that isn't essential or for work purposes, the U.S. Customs and Border Protection is discouraging that. Due to COVID numbers, obviously Americans are, often not permitted in various countries or with significant restrictions. I was looking at South Korea the other day, and essentially many countries are now requiring, several $1,000 deposits for U.S. citizens to go abroad. So certainly a lot of these restrictions are in place. A lot of the U.S. embassies abroad are partially closed. And what I mean by that is that essentially they are only open to emergency cases. And that means if you're a healthcare worker or alternatively a medical researcher, you might be able to get into the country or alternatively get a consular interview, but often, it's very difficult. I mentioned earlier sort of the closed borders. Interestingly, even though the U.S.-Canadian border and Mexican border are effectively closed, we are still seeing the use of TN visas. And so certainly that is still something that is feasible to apply for and even to obtain. Earlier, around June or so, President Trump issued a proclamation that basically stopped the issuance of new H-1B, J-1, and L-1 visas. So these are a lot of work-based visas that normally would allow a bachelor degree worker into the United States. Note that this is for new visas, so individuals who are already in the United States and maybe need a renewal, they will certainly be permitted to obtain those renewals. Individuals also in the United States under an F1 international student visa will also be permitted to transition to H-1B or J-1 or L-1 status. Around October 8th, there were new regulations issued by the Department of Homeland Security and also the Department of Labor regarding H-1B visas and permanent residency processes, so green card processes effectively. And I'm going to talk about that in sort of greater detail. For any employer that is in this world, this has been a pretty stark change. So on October 8th, we had the Department of Homeland Security and Department of Labor issue what's called an interim final regulation. There were three components to that interim final regulation that employers would care about or want to know about. So number one, there's going to be an increase in the Department of Labor prevailing wages for H-1B and perm labor certification. So that's a lot of immigration terminology for the minimum wage for H-1B workers has been raised by 30 to 60%. And these so-called prevailing wages, these are set by the U.S. Department of Labor. They're unique to each county and they're unique to each job category. So, for example, if you're looking at a software developer in San Jose, that might be at $200,000, and a software developer in Salt Lake City, Utah, would be roughly maybe $110,000 or so in terms of that prevailing wage. The prevailing wage also does vary based upon the education and experience that is required. And so when H-1B visas were created more than a decade ago, there was the requirement that all H-1B workers be paid the higher of the prevailing wage, so this Department of Labor mandated prevailing wage, or alternatively, the comparable wage paid to other similarly situated workers, right? So if you've got a U.S. citizen worker that is getting paid $100,000 as a computer programmer, then you would have to pay an H-1B worker who had the same, more or less, resume performing the same job $100,000 as well, regardless of what the Department of labor prevailing wage is. So this is basically a bottom floor to ensure that immigrant workers and H-1B workers are not basically kind of undercutting the U.S. worker salaries. This does impact prevailing wages for something referred to as the green card process, the perm labor certification process. For those of you who deal with the world of immigration, you'll know that the perm labor certification process is the first step in the green card process, and it's a process which requires you as an employer to demonstrate that there's no minimally qualified U.S. worker that can take on that particular role. Requires you to advertise in 2 Sunday newspapers and about 6 other different locations and interview various U.S. citizen workers to determine ultimately that they do not meet the minimum requirements for the position. As part of that advertising process, you do have to actively seek a prevailing wage to confirm what the appropriate salary to advertise is at. So that's the Department of Labor prevailing wage changes, and they have spiked, essentially. They've gone up 30 to 60%. That was immediate in terms of the impact as of October 8th of 2020. I will mention this kind of further on, but there's essentially 2 ongoing lawsuits in federal court to enjoin the implementation of these prevailing wages. We have not necessarily seen that injunction occur yet, but it may occur. So those 2 lawsuits were brought by the tech industry and by immigration attorneys. There's a new rule that implicates the definition, the third-party work sites. So when you have an H-1B worker that's placed at a third-party work site, then those H-1B visas are shortened to a 1-year period of time. So the reason why the Trump administration and these government agencies have sort of released this new restriction, when you look at the top H-1B employers, they are not, Microsoft, Apple, and Amazon. They are companies like Satya, Cognizant, Infosys. These are primarily Indian headquartered companies that have a presence in the United States that are placing their high-tech software developers at third-party work sites. And so in an effort to kind of curb the high use of the H-1B visas by these companies, the government has restricted those H-1B workers to a 1-year period of time. You'll note that employers that are in this world, you might have high-tech software developers that are at your work site, but they're not on your payroll. And those are the types of workers that we are talking about. Both the Trump and the Obama administration have tried a number of measures to curtail the use of H-1B visas by these sort of other companies, and that has included doubling the immigration fees, the government filing fees associated with the H-1B process to roughly about $4,000 for employers that had more than 50% of their workforce under H or L status. It also included examining and requesting documents to show that immigrant workers actually had an employer-employee relationship with that company. So, for example, Infosys or Cognizant would have to demonstrate, yes, we are actually managing this worker despite the fact that he is not physically on site. We are, assigning tasks or giving him sort of the tools to be able to do his work. The last sort of component is the redefinition of or kind of curtailment of the definition of specialty occupation. So H-1B visas must qualify as specialty occupations. Specialty occupations are generally defined as positions that require a bachelor's degree where a bachelor's degree is required in a specific major. So, for example, a sales job, which doesn't necessarily require a bachelor's degree, is not a specialty occupation, would not qualify as an H-1B visa. And general managerial positions have come under a lot of scrutiny for H-1B visas as well, generally do not qualify. The Trump administration, early in around 2017, had issued guidance sort of placing greater scrutiny on lower paid workers, so kind of as well as entry-level positions, as well as positions that were kind of generally lower on the prevailing wage scale. So for the 4 levels of prevailing wage, if you are at the bottom, at the level 1 prevailing wage, it would potentially be harder to qualify for an H-1B visa. And this has really kind of demonstrated itself in the real world. The USCIS has quadrupled the number of H-1B cases over the last 2 years that they have denied under kind of this higher standard and scrutiny. What this specific interim final regulation puts into play is it is essentially stating that they want to see for every worker that you have hired for, I don't know, a marketing analyst, for instance, that every single one of those workers not only has a bachelor's degree, but has a bachelor's degree in marketing. So if you have hired in the past somebody in that marketing role who has, maybe it's an economics major, maybe it's another liberal arts major, that would undercut your case and likely lead to an H-1B denial. So anyways, this does certainly make it more difficult. We see this come into play for, let's say, somebody who's a software developer but has an electrical engineering degree or an industrial engineering degree. So basically a bachelor's degree, but in a mismatching area or field. And so certainly that can be problematic. And I think ultimately, an employer in those sort of situations should be forewarned that the case may certainly lead to a denial. In the real world, certainly this is keeping up a lot of immigrant employees. It's causing them a lot of anxiety. And it's causing a lot of employers to move forward in paying something called premium processing. It's kind of like a $2,500 expedite fee to try to get a response faster to these cases so that they can secure an approval as early as possible. I would note that the immigration agency, they have had decreased filings, and that's led to a budget shortfall. The U.S. Citizenship and Immigration Service is one of the very few government agencies which solely relies upon government fees as opposed to taxpayer dollars. So effectively, U.S. citizens are not paying to run the immigration agency. It is effectively immigrants who are paying to run the immigration agency. And so as part of that budget shortfall, there was going to be a hike in immigration fees. What ultimately sort of it has come down to is basically an increase in premium processing fees. So that's been increased from $1,440 to $2,500. So the $2,500 gets you as an employer a response in 15 calendar days as opposed to potentially 3 to 7 months. The last 2 components of this interim final regulation go into effect on December 7th of 2020. And so we'll see how this continues to play out. If the transition to a Biden administration, we have not necessarily seen or articulated whether these would be changes that the Biden administration would reverse. Certainly, if we look at the track record of the Obama administration, I think certainly the Obama administration, we were seeing H-1B approval rates kind of in the 90 percentile, so at relatively high rates. Obama administration also was very sympathetic to H-1B workers. They instituted something called the H-4 Work Authorization, or EAD, Employment Authorization Document. So that permitted H-1B spouses under H-4 dependent status to work in the United States. So that certainly had a very positive effect for certain workers. I would note that the Obama administration was equally as, strong or resistant against some of these third-party work sites, as well as the third-party work sites, as well as consular, some of these Indian subcontractors that are placing their workers in work sites that are not their own. The last change here, and this was released on November 2nd, many of you who deal with H-1B visas may be aware of the fact that there's effectively a lottery. So H-1B visas are limited to 85,000 per year, and that's 20,000 that are set aside for graduate degree workers and roughly 65,000 for bachelor degree workers. And one would think that that's a lot, but unfortunately that is not a lot. Each year, there's a lot of employers who file to basically obtain one of these H-1B visas. Past year, in April of 2020 or March of 2020, there were about 250,000 applications submitted by employers on behalf of immigrant workers for those 85,000 spots. So just doing that 250,000 divided by 85,000, each of these workers probably has about a 30% chance of receiving an H-1B visa, with grad degree workers having a slightly higher chance of obtaining one of these H-1B visas. So this past year, in March of 2020, was the first year in which the government used an electronic lottery. It was called a pre-registration process. And so rather than submitting a full-blown H-1B application and kind of incurring a lot of legal fees to do that, the government set up a website which permitted them for $10, employers for $10, to submit kind of a lottery registration. And then around March 20th, you were informed as an employer whether or not your application was received and selected within the lottery, and then from that point you were permitted to submit a full-blown application in 60 days. So under this new regulation released on November 2nd, anyways, there's a reassignment and prioritization of cases with a higher prevailing wage. And so what that means is that, level 4 H-1B applicants would have first priority, and moving on down to level 3, let's say at, $150,000 for that prevailing wage, would have next priority, and on and on. They specifically disclaimed that level 1 prevailing wage workers will not qualify for the lottery, which is certainly a stark slap in the face. Many of these workers, you could be a physician earning $200,000, but many of these workers are coming off of F1 optional practical training, so they're just newly graduated effectively often, and that means that effectively they typically are occupying somewhat entry-level type positions, although they may be taking greater responsibility beyond that. I will also mention a major significant change for employers that are sponsoring their workers for green cards. There's a new public charge rule, and so this has been implemented by the Trump administration. This was revealed and effective in February of 2020. It requires a new form, specifically called the I-944 Certificate of Self-Sufficiency. And the idea there is that any immigrant worker who is applying for a green card must show that they will not be likely to incur basically welfare or other federal services. So basically, the new requirement reviews green card applications to determine whether applicants are more likely than not to require public benefits. Think of things like TAMF or food stamps. So greater financial information is now required for each of the applicants' employees and dependents. So this involves everything from credit checks to evidence of debts and assets like mortgage statements, like residential tax statements. In the main, employees who are at 250% of the poverty guideline, which is roughly about 65,000, they will not be subject to as great of scrutiny. But even the government is even putting at play or at risk. These are spouses who might stay at home, who are, who stay home and help to raise children. It is asking about the education and sort of English fluency of those particular workers. And so it is one of the most sort of onerous, invasive pieces of information that have been requested by the U.S. Citizenship and Immigration Service. I would note that unemployment insurance benefits, particularly in the time of COVID, they're not considered an adverse factor. So the fact that if somebody became unemployed and still sought a green card and was currently incurring some sort of unemployment benefits, that will not be an adverse factor. We have seen significant federal litigation challenging this new requirement, and it is certainly very much possible that this could be reversed. Earlier in the month, there was a federal district court that temporarily enjoined for one day sort of the implementation of this I-944 form or this requirement for self-sufficiency, and then that was reversed by the said circuit. So I anticipate that we may have, different circuit courts that come to different decisions as to kind of how this should be put into play or not. Ultimately, with a Biden administration, I would expect to see kind of a liberalizing of the use of immigration visas. And so that may increase both H-1B approval rates as well as green card sort of approval rates. This public charge component is not something that I would expect Biden administration to support, and they may entirely rescind this. So we'll see where it goes from there. And our firm will be offering a webinar on Biden administration immigration changes here over the next few months. So be on the watch out for that. I think with that, we will turn it back to the broader group. And anyways, this is your opportunity to ask any questions that you might have.
Yeah, and this is Tyson. I see a couple of questions on there. One regarding Governor Herbert's new mandate here in Utah and what he's going to do as far as enforcing the noncompliance with businesses who do not comply with the mandate. At this point, we haven't seen what he means by enforce. We're trying to get a better understanding of that as we get more information. We'll let people know. But it sounds like it's going to be your standard enforcement, whatever that means. I don't see a specific task force going around to businesses knocking on doors, but, who knows? We'll see. And then also, must we take disciplinary action against employees who continually fail to wear masks in public spaces at work? Again, this is going to come down to your policies. This is why it's important to have written policies that are clear, that have been distributed to your employees, that your employees have been trained upon, and that you have also uniformly applied. And so once you have that, then you have the ability, like any other policy, to go to your employees and say, hey, you're failing to comply. Again, we would recommend before you take any disciplinary actions for, failing to wear masks or not attending work due to COVID-related issues or concerns, we recommend that you reach out and then we talk about it just to make sure there aren't any qualifying risks that we may want to discuss and evaluate. So, any other questions from anybody? We'll give it just a little bit long, a couple seconds here to see if anyone's typing any questions.
Tyson, I did get a private message from somebody who asked if somebody can speak on FFCRA exemptions.
What was that?
I had a message come into me asking if someone can speak on FFCRA exemptions.
Yeah, so I assume you're talking there about the payment for employees that are taking leave under the Emergency Paid Sick Leave Act or the Emergency FMLA. Those, again, not sure necessarily what exemptions you're looking for. Maybe what companies doesn't apply to that. It applies to all companies from 0 to 500 employees, and so it does have a broad scope of application. As far as who qualifies, there's a number of qualifying factors, and the amount of pay that they would receive and which type of leave they're entitled to depends on whether they're taking the leave for themselves or for the care of others. If they are taking leave to care for because they've been asked to quarantine or have COVID, then they are entitled to full pay over a 2-week period. The other type of leaves entitles them to 2/3 pay. Emergency FMLA, that's only applicable if you have a child who's unable to attend school due to a closed daycare or school facility. Again, this is such a broad topic. We've done full presentation, hour-long presentations just on those two new laws. But if you have any questions on those or any specific questions, please reach out to us. Again, that's something that we address every day. We get questions on that routinely. So if you have any more specific questions, please let us know. Deborah, it looks like there's a question that just came in for you.
Oh, sure. So this question is about the outbreak requirements. So if a business has 2 cases in 14 days, the obligation to send others home from the area, the floor, or the entire workforce. It varies. I wish I had just a straight answer that applied to everyone uniformly, but this varies from state to state. It varies from county to county, and even from week to week. In Colorado right now, with the new public health order that just came out, counties are categorized as different colors on a dial, which sounds fun, but not really. So Denver, for example, I think we're level orange or level red right now, which means it's very high risk, and there are going to be more stringent requirements to send workers home if you've got an outbreak. In some of the other counties in the state at a lower level, the requirements are a little bit different. So to some, it varies. If you want to talk offline, give me a little more details. I'm happy to give you a more specific answer.
I think that's all the questions that have come in. I apologize, I was talking on mute a minute ago, but I think we've addressed all the questions. If anyone has any specific questions or anything follow-up, please let us know. We will be sending out the slides to all the participants along with the recording, and in there you'll be able to have access to our bios and our phone numbers. Again, we appreciate everybody attending today and for your involvement. If you have any questions, we'll talk to you soon.